Well, I think that interpreting at the Court of Justice is one of the most interesting jobs an interpreter can do. A lot of people say, oh no, I wouldn't like to work there. It's always difficult, it's complicated, it's legal. But the fact is that every case you interpret is different, and the range of subjects we cover is quite phenomenal. The case that I always quote as an example was the test tube pregnancy case. A woman was dismissed from her post in Germany because she was absent, and she was absent because she was undergoing fertility treatment. Everybody knows that there's European Union legislation which says you cannot dismiss women who are pregnant. And the question which came before the court was the question that her employer raised, namely, was she really pregnant if she was undergoing fertility treatment? That's, to my mind, a very interesting issue, and one which is not at all removed from everyday life. The court's rulings do have an effect on the parties involved in the case. The fact that you are in this position of responsibility, I think, makes you want to do your best. All interpreters have a sense of responsibility, a sense of professionalism, which makes them go into the booth as well prepared as they possibly can be. We are allowed time to study the file of the case. Freelancers who are recruited to work for the court are given an extra day's paid employment, which gives them the time to sit down and read through the documents. I know that people working for the Parliament and the Commission are told in advance which meetings they're going to be sent to, and I think that they're given some indication as to which documents are going to form the basis of discussions. But I know that they're not given the amount of time we are to prepare. All interpreters have to be precise, but you do really have to try and get exactly the right term at the court, because you're talking about legal concept. We really need to know the case inside out before we go into the booth, because the hearings are A, quite short, and B, each party to the case is given quite a short time, usually only about 15 or 20 minutes, to put their point of view. And so they tend to do it very fast. They've thought it out in advance. Very often they come with a text, which we then ask them to give us. They read off their text at top speed, or they answer questions at top speed, and they refer to case law and legislation very much in passing, because they know what they're talking about, the judges know what they're talking about, and we need to know what they're talking about as well.